We often get asked by potential clients, what is the value of incorporating a revocable living trust into an estate plan? While there are a myriad of types of trusts that are used and utilized for different purposes, a revocable living trust is one of the more common ways that clients can avoid probate. Probate is the court administration process of administering an estate after death. When an individual dies with assets that are in his or her sole name without a beneficiary or a joint owner, those assets require probate in DC, Maryland, and Virginia in most cases. We can avoid that probate process and avoid that delay by creating a revocable living trust while the individual is alive and well and can make those decisions. The sole purpose of a revocable living trust is to avoid the probate process. The operation of the trust is that we create the trust and we begin to retitle assets into the trust while the individual is alive. Any assets that are titled into that trust avoid probate and are governed by the terms of the trust document. Often, the creator or the grantor is the initial trustee as well as the initial beneficiary of the trust. And during his or her lifetime, that trust can be amended, changed, revoked, either entirely or in part. Assets can be added to the trust or removed from the trust. And the trust remains flexible for the care and the use of the individual who created it, who is also the initial beneficiary. At either death or incapacity, whichever is the first to occur, the trust becomes irrevocable and it is administered according to the provisions that have already been supplied to accommodate the wishes of the grantor. This provides for a very streamlined mechanism of management during an individual's lifetime through incapacity into death. The revocable living trust can also include some estate tax savings provisions. It can include sub-trusts for minor children or beneficiaries with special needs, and is a very flexible tool to save time and expense through the probate process.